Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I'm going to cover an article in the Toronto Star. Toronto cop docked 8 days pay after judge finds his account of drug arrest simply could not have happened. So this will be part one of a two-part video. Part two will be going in and looking at the actual underlying case. But for right now, let's look at the article, which is about the disciplinary proceeding, and I'll have comments about that and probably return to some comments about the article after part two. However, for right now, let's go into the article here. A Toronto police officer blasted by an Ontario judge for testifying with little regard for truth or accuracy, leading to an arbitrary detention and the collapse of a gun and drug prosecution, has been docked 8 days' pay at a police disciplinary hearing. So there's a lot to break down here. First thing is the arbitrary detention and the collapse of a gun and drug prosecution. What that means is that as a result of the officer's conduct, it was found that there was a charter violation here, and the evidence that was obtained as a result, including the gun and the drugs, were excluded from being used at the trial. Now, the Crown is not going to be able to prove possession of a gun or possession of a drug if they're not allowed to refer to the existence of the guns or the drugs. So that's the end of the case. The accused walks on those things, notwithstanding the fact that the accused was found with a gun and with drugs, which is a bit of a big deal for society. However, it's also a big deal for society if we sometimes don't let people walk on those kinds of charges, because this can also be a problem for reasons we'll see in this disciplinary decision. When they say, with little regard for truth or accuracy, I will let you decide as to whether or not you would use a different word here. The courts, particularly with respect to police officers, seem to tiptoe up to certain things they might otherwise find without sort of stepping over that line. And that's because, police officers can and maybe should face some career consequences if they are found to be dishonest in a courtroom. Now, they also note 8 days pay. Now, 8 days pay, you're going, what does that mean? Well, as it turns out, this individual, from what I understand, is on the Sunshine List, and the 8 days pay works out to about $1,500. In the scope of fines, that's not a huge amount. I've seen people fined substantially more for offenses that I thought were substantially less serious. You can get fines of more than $1,500 for traffic offenses here in Alberta, and people do all the time. So this is less serious than certain traffic offenses, I guess, like driving with no insurance. I don't know. I kind of feel like testifying with little regard for truth or accuracy might be a more serious societal thing than that. But carrying on. Constable Michael Reeves pleaded guilty to 1 count of discreditable conduct at the Toronto Police Tribunal after a scathing rebuke from Ontario Judge Philip Downs, who found that a drug transaction Reeves claimed he'd witnessed simply could not have happened as described, and noted that this is a troubling and serious finding to have to make, and called it severe state misconduct from which the courts must dissociate themselves by excluding evidence linked to that conduct. I should note here that Canada is unlike some other countries that have this sort of rights-based system. Some countries, for instance, the US, it's if your rights are violated. My sort of limited understanding of US law is that basically at that point the evidence is gone. Canada introduces a second step. It's not just that because your rights were violated to get the evidence, that evidence is automatically out. There's actually a consideration that includes a whole bunch of things, like the seriousness of the conduct, the importance of the evidence for the Crown, as well as society's interest in having the case heard on its merits, as opposed to being shot down essentially by a charter argument. So there's that second step. And so what often happens in Canadian courts is that the courts might say somebody's rights were violated. However, anyway, notwithstanding that rights violation, we are still going to allow that evidence in, and that person may or may not be convicted. So this exclusion of evidence isn't just an automatic step. It's a bit of an unusual or, sort of special step. The court noted that this was a difficult decision, but ultimately excluded the evidence. In a brief hearing before the Toronto Police Tribunal Monday, hearing officer, I think that's Superintendent Riaz Hussein, classified Reeves' misconduct as serious, finding that his actions showed a lack of judgment and did not live up to the expectations of a police officer. I would agree with that. The expectations of a police officer do include that your testimony in court is things that are true and accurate, and that you have regard for those things, because the court finding was that he had little regard for truth or accuracy. So carrying on here, 8 days dock pay is within the range of penalties of other cases involving similar misconduct, Hussein said, crediting Reeves for the early guilty plea and noting the officer had made numerous positive documentations. Let's sort of think about this. First, if 8 days dock pay is within the range of penalties, that kind of suggests to me that maybe the range of penalties might be a little skewed in the downward direction. Maybe it should go up. Now, I'm not normally a big proponent of sort of harsh penalties for deterrence, and that is because most criminal activity is done by people who are very difficult to deter in the standard fashion, because they are mentally ill, they're desperately poor, they are addicted. All of these people are driven by forces that are greater than any punishment our system can impose. That's not true of police officers, who we assume are probably more thoughtful people, more in control of their actions, more able to reason through the consequences of their actions. So, if deterrence works at all, police officers are really an ideal test group, and $1,500 to me does not seem like a super strong deterrence. Also, when we're talking about numerous positive documentations, well, once you've got an officer who has been caught testifying with little regard for truth or accuracy, doesn't that kind of throw those other positive documentations into doubt? Doesn't that kind of throw every other trial that this officer might have testified in into doubt? As we'll see here, the reason why this officer was caught out in this was because there was video evidence that contradicted the officers. The officer's testimony was utterly incompatible with the video evidence. So there's going to be plenty of cases where that's not the case. And so how do we know that there wasn't similar problems that just weren't spotted? So when we say numerous positive documentations, I don't really know how much weight I think we should put on that, because maybe those aren't actually positive documentations at all. Maybe those are just situations where people might have been improperly sent to jail. Reeves' lawyer said he made a mistake and he owned up to it. He didn't intend to mislead anyone, especially the court. Well, I don't think that's necessarily a point in his favor. If it's, if he didn't intend to mislead anyone, and this is just some sort of terrible accident that just happened somehow by reasons we can't understand, then how do we know he's not going to do it again? If it's something that's beyond his control, well, if it's beyond his control, how can it be a mistake? But if it's beyond his control and he didn't intend to mislead anyone, how do we know that it's not just something that's going to happen again? And if he didn't intend to mislead anyone, what's he pleading guilty to? How is this discreditable conduct if it's just accidental? And what was he intending to do if not mislead somebody when they're testifying, as the court found, with little regard for truth or accuracy? I don't have good answers to these, and I suspect there just might not be good answers to this. Mr. Stevens' lawyer, that's the accused, said in a statement Monday that there's still a problem where some officers pursue a strategy of the end justifying the means. But she said it's reassuring that the criminal justice system does work when the officers' fictionalized events were recognized by the judge. The word doing a ton of heavy lifting on this one is right here. When the officers' fictionalized events were recognized by the judge. Because what if they aren't? That's the concern with officers who are not testifying accurately, is that their comments might not be recognized by the judge. And that might be a big problem. She went on to say, Although I believe the penalty given to Officer Rees is too lenient, it is a promising step in the right direction towards determining similar future actions. I don't know if I agree. I don't think this is a whole lot of deterrence here. This is more of a price tag. This is a cost of doing business. I don't see that this is a real strong deterrence, and I don't even know that deterrence is the right thing. There's two elements. I think that you may need to deter other officers, but in this case, the main thing I think is that this officer, once you find that they have testified without regard to truth or accuracy, that should really be precluding somebody from being an officer. And I mean precluded in the same way that if I lost my voice, I would not be able to continue doing these videos. You're just fundamentally unsuited for the task at hand. Similarly, a lawyer would be disbarred if they were found to have lied in court, or, for instance, if they stole from trust money. I don't see why we treat police officers so much more leniently. I will tell you that if the court found that I had testified with little regard for truth or accuracy, the Law Society would not be letting me off on a $1,500 fine. It would be a little bit more serious than that. Why is it that police officers who arguably, if you ask society who they trust more, lawyers or police officers, lawyers have never won that one. Like, never. Unless maybe you're asking lawyers. But why is it that the officer is getting off with $1,500 in fines? That is a trivial amount when you think about what we fine other people for. So anyway, I don't want to get into too much about the details of the allegations here. Suffice to say that the officer indicated that he witnessed a transaction, and that on review of camera footage that was available, it was clear that what the officer testified he could see and, had seen was simply not possible. It was just no way that that could have occurred. And as a result of that, the court, notwithstanding the fact that they made comments about saying, I have seen the danger that frontline police officers face every day in tackling gun crime and in answering the call to try and keep communities safe from the cowardice that gun crime represents. Those responsible for endangering our communities must pay a heavy price, and saying that the court has no sympathy for individuals who threaten their own neighborhoods by walking around with loaded firearms. The court still found that it was necessary to distance the court from the conduct of the police revealed in the case. Essentially, that if the court were to allow that evidence in, that evidence is so tainted by the charter violation that it would sully the court. That, I think, is a very strong statement. And typically people will blame defense counsel for defense and say, this bad defense lawyer, and I don't think this is a bad defense lawyer. This is a defense lawyer who did their job. But, they got this person who is a dangerous drug dealer with a gun, and they're on the street because of this defense lawyer. Well, they're not on the street because of the defense lawyer. The defense lawyer is the person who did their job. They're on the street because of the police officer, who is the person who, as the court found, didn't do their job, to wit, testifying honestly in court and respecting the charter rights of Canadian citizens. So I have all sorts of problems with this, and I think that this is a situation where the police have been rocked with issue after issue in terms of maintaining public confidence in their activities and in their actions. How are they supposed to regain public confidence in those interactions with $1,500 as the penalty? I don't see it. Anyway, thank you for watching. Please like this video. Please share it with your friends. Please subscribe to see more content. And I'm going to be trying something a little different with the Patreon crawl here. So let me know in the comments below what you think of that as well. Thank you once again, and I hope this has armed you with knowledge. Want to thank my Patreon supporters at the $50 level: Sir Daniel Wicks of Alberta, Jason Elliott, D-Mo, Canada's National Firearms Association, North Central Process Service, Kyle Martin, and Jean-Guy Toussaint. At the $30 level, Sights and Arms Limited. And at the $20 level, Dale Nesbitt, Cameron Johnson, and Andrew Elsich. As well as to all of my $10 supporters who are on the crawl, which hopefully is on the page right now. Thank you once again for watching, and I hope this has armed you with knowledge.